Hi everyone, my name is Maxwell Williamson and I will present the Ninth Circuit's decision in Holzhauer v. Golden Gate Bridge Highway and Transportation District. The parties involved were lifelong friends David Rose and Harry Holzhauer. They were riding together in Rhodes' 22-foot speedboat when it collided with a ferry belonging to the Golden Gate Bridge Highway and Transportation District, hereafter the GGB. According to a witness on the ferry, neither Rhodes nor Holzhauer were looking toward the ferry when the collision occurred. In fact, both were looking at the city's skyline when their boat crashed into the ferry. Holzhauer, who was at the helm of Rhodes' vessel at the time of the collision, died from his injuries, and David Rhodes was seriously injured. Consequently, Holzhauer's wife, in her individual capacity and as representative of her late husband's estate, sued Rhodes for negligence in the District Court for the Northern District of California, and arguing that Rhodes failed to act reasonably either as a vessel owner or as a passenger. Ultimately, the question that stood before the District Court was whether Rhodes acted reasonably either as a vessel owner, although as a passenger he failed to maintain a lookout. Ultimately, to identify the lookout duties of an owner-passenger, Holzhauer drew attention to the 11th Circuit's decision in Wiseman v. Boating Magazine. That case addressed the lookout duties of a normal passenger, and the court determined that passengers in a recreational vessel, like those in automobiles, have a presumed lack of a lookout duty. Furthermore, the 11th Circuit recognized exceptions to that presumption, which come into play when a passenger knows that the operator is likely to be inattentive or careless, or when the passenger is jointly operating the vessel with the operator. The 11th Circuit adopted the concept of joint operation because in Wiseman, the operator was conducting various performance tests on the vessel, which included monitoring the vessel's speedometer and tachometer, and most importantly was relying on the passenger to look out for hazards. The rationale of the concept of joint operation was that a passenger in the moment of a collision and those leading up to it was more than a mere passenger because he shared a responsibility for and control over certain aspects of navigation and therefore held a duty of care to the vessel. At trial, Holzhauer argued that the 11th Circuit provided the correct scope of a passenger's lookout duties, but an owner-passenger like David Rhodes was excluded from the 11th Circuit's decision because, according to the United States Supreme Court's decision in Cremerac v. Compagnia Generale Transatlantique, a vessel owner has a duty to exercise reasonable care to all passengers on board their vessel. Holzhauer argued that this obligation precludes an owner-passenger from having a presumed lack of a lookout duty because that duty of exercising reasonable care includes a vessel owner maintaining a lookout at all times. In other words, Rhodes had a greater lookout duty that he failed to adhere to when the collision occurred. At trial, the District Court found Rhodes acted reasonably since he was not jointly operating the vessel at the time of the collision, and followed by granting his motion for judgment as a matter of law. At the close of trial, the jury allocated 70% of fault in collision to Harry Holzhauer and 30% of fault to GGB. On appeal, Holzhauer and GGB argued that the district applied the incorrect legal standard for determining Rhodes' duty of care. Holzhauer argued that the district court's decision went too far by giving a vessel owner the same lookout duty as a regular passenger. Under first impression, the Ninth Circuit attempted to resolve the tension between the Supreme Court's decision and the 11th Circuit's decision by applying the tort of negligent entrustment because an important consideration in this case was that Rhodes entrusted his vessel to Holzhauer. The tort of negligent entrustment imposes liability on a vessel owner who has entrusted control of their vessel to an individual who is likely to harm or intends to harm individuals or property while at the helm. The Ninth Circuit did not believe Rhodes negligently entrusted his vessel because the court accepted the view that Holzhauer was a safe, cautious, and experienced boat operator. Furthermore, the Ninth Circuit emphasized its desire to avoid creating a circuit split with the 11th Circuit solely because the passenger in this case was also the vessel owner. That consideration partially contributed to cause the Ninth Circuit to hold that vessel owners who ride in their vessel as a passenger have the same lookout duties as a regular passenger. There are two problems with the Ninth Circuit's decision. The first problem pertains to the Ninth Circuit's conclusion that Holzhauer was a competent operator and therefore did not warrant Rhodes to act as a lookout. In particular, the court discounted concerning facts on the record, including that Rhodes had to explain the rules of roads for passing. This fact should have been afforded greater consideration because it provides indication that Holzhauer was not a truly experienced boater. Furthermore, the rules of the road of passing is a critical element of safe navigation, especially in San Francisco Bay, where military vessels, cruise ships, ferries, and personal crafts crowd the waters. Here, roads had a reasonable indication that Holzhauer needed supervision because Holzhauer needed to have the rules of the road for passing explained. The consequence of concluding roads acted reasonably, despite these considerations, is that courts in the future are left with a cursory evaluation of an operator's actual experience level in the context of negligent entrustment. The second problem with the court's conclusion is that the court adopted verbatim the lookout duties of the 11th Circuit. As mentioned before, the 11th Circuit recognized that passengers who share an active responsibility for and control over the navigation of the boat owe a duty of care to the vessel. The court recognized this scenario causes a passenger to become more than a mere passenger. In the case of Holzhauer, since Rhodes was the only person experienced with the rules of the road for passing, the Ninth Circuit should have concluded that Rhodes was more than a mere passenger because his knowledge gave him a special responsibility for and control over navigation of the vessel. By overlooking the 11th Circuit's appreciation for circumstances when a passenger is more than a mere passenger, the Ninth Circuit adopted a narrow interpretation that will likely provide little guidance in collisions that fall outside the scope of joint operation or being inattentive or careless. For instance, those exceptions do not compel a passenger to look out when the operator may be experienced and competent, like Holzhauer was, but is relying on the owner passenger for supervision or assistance. In closing, the two circumstances requiring an owner passenger to act as a lookout are a good step forward in improving safety navigation, but the vessel owner's duty to exercise reasonable care should not end when a vessel owner entrusts his vessel to a person that is unfamiliar with the waterway's rules of the road for passing, especially in a congested body of water such as San Francisco Bay. For now, the owner of any pleasure craft in the vast navigable waters of the Ninth Circuit can simply state the rules of the road for passing, give the helm of their vessel to anyone who's operated one before, and sit back and relax. Look out.